Hello everyone, my name is John. Welcome back to the channel. I want to start today's video with the scenario. Imagine, if you will, you're the head coach for a college football team and your team is going to the championship and you and your opponent are pretty evenly matched. However, something happens. About 1 month before the championship game, the other team acquires your assistant head coach. Your right-hand man, the one that knows you, he knows your personality, he knows your plays, he knows the team, he knows the quarterback for your team, he knows everything about your organization, backwards and forwards. And now he is working for the other team. So now this team that you're pretty evenly matched with, who has the advantage now? Now take that same scenario and imagine an FDA lawyer whose job it is public safety. His job at the FDA is to protect us against the foods that are being sold to us, the things that we consume on a daily basis. It's their job to make sure that nothing harmful to us will slip through the cracks. Well, now these companies acquire those lawyers, and they now work for these massive companies. The companies that are selling us these potential harmful products. Now who has the advantage? They have the lawyers that knows the litigation. They knows the ins and out of the FDA. They know how to navigate the waters, and now they are working for these companies. Who has the advantage now? This is eye-opening, and you don't want to miss it, so stick around. In 2023, Perham Gorji left his position as a senior FDA attorney responsible for regulating tobacco companies to become a litigation partner at DLA Piper, one of the world's biggest law firms. His job at the FDA, leading the agency's legal battle against tobacco and e-cigarette companies. His new job, representing Philip Morris International as they seek FDA approval for their latest tobacco products. This isn't just a career change. It's a perfect example of how the revolving door between regulators and industry undermines public health protection. And according to a comprehensive investigation by the examination, Gorji is just one of nearly 24 FDA lawyers who have made similar moves in the past 15 years. During his time at the FDA, Perham Gorji was described as a career government lawyer, helping to lead the U.S. Food and Drug Administration's battle against tobacco and e-cigarettes. He was there as the agency contemplated banning menthol cigarettes and as vaping products flooded the market, hooking a new generation on nicotine. As the FDA's lead litigator, Gorji represented the agency on multiple tobacco matters and defended the agency's regulatory approach to menthol-flavored cigarettes, products that public health experts say could save thousands of lives if banned. Now, at DLA Piper, Gorji advises Philip Morris International as they work to get their newest tobacco heating device, IQOS, approved by the very agency he used to represent. The irony is striking. The lawyer who once defended the FDA's slow pace on menthol regulation now helps tobacco companies navigate those same regulatory processes. Gorji's career move isn't unique. It's part of a systematic pattern. According to the examination's investigation, in the last 15 years, nearly 24 FDA lawyers have left the agency and its Center for Tobacco Products to advise, litigate for, or work with the tobacco and vaping industry. The impact on the agency is so severe that FDA Commissioner Robert Califf openly acknowledged the challenge. It seems like every time we get sued in the tobacco industry, a former FDA lawyer is leading the lawsuit. The FDA is facing what Califf calls an epic struggle with the tobacco industry, fighting legal battles every single day. But these battles are particularly frustrating because many opponents are represented by former FDA insiders who helped craft the very regulations the industry is now fighting. This raises uncomfortable questions about how regulatory agencies can maintain independence when their own lawyers regularly transition to lucrative industry positions. The financial incentives driving these career moves are substantial and impossible to ignore. According to the examination's research, an FDA lawyer's starting salary is around $83,000. A first-year lawyer at a major firm averages $200,000 annually. Partners at DLA Piper average $1.3 million per year, more than 6 times what Gorji made when he left the FDA. Daniel Aaron, a former FDA attorney, now teaching at University of Utah, explained the advantage these career moves provide to tobacco companies. It's a huge advantage to getting your product to market. Ex-FDA lawyers know what the agency is worried about and how a client can maximize its options. They know not just what the law is, but they know how the FDA will enforce the law. One might wonder if current FDA attorneys are influenced by the knowledge that aggressive enforcement against tobacco companies could limit their future career opportunities in lucrative private practice. Now, Philip Morris has employed a tactic that constitutes regulatory capture. Now, they're hiring these FDA lawyers. Well, why would they do that? Part of the reason they want to hire them is to gain inside knowledge of regulatory processes. Over the years, Philip Morris has hired multiple FDA lawyers to senior positions. Internal Philip Morris documents reveal strategies dating back all the way to the 90s, shows the company developing strategies to influence regulation and weaken tobacco control efforts. Now, what you're going to find as we continue to bring these things to light is that the same tactics and strategies that the tobacco industry used way back when are still used today. It's the same playbook. The food manufacturers, the processing plants, the large beverage companies, Coke, Pepsi, all of these companies are using the same tactics and the same playbook. So these strategies are really not new. The revolving door problem extends beyond senior attorneys to enforcement officials. Jessica Tierney joined the FDA's Center for Tobacco Products straight out of law school in 2011, working her way up to oversee enforcement against e-cigarette manufacturers selling products illegally to minors. In October 2021, the FDA denied millions of e-cigarette applications while approving only 3 products. Tierney played a key role in this enforcement effort. Just months later, she left the FDA to join Thompson Hine Law Firm, which defends e-cigarette makers. Her new clients included companies that had been cited by her previous enforcement division for illegally marketing e-cigarettes. Tierney immediately got to work, submitting records requests to her former agency and representing companies challenging the very decisions she had helped make as an FDA official. The case she's now working on has reached the Supreme Court, where oral arguments are scheduled for December 2024. The conflicts weren't lost on FDA insiders. Eric Lindblom, who directed the Center for Tobacco Products Office of Policy from 2011 to 2016, proposed blocking former staff from working for the tobacco industry for at least 1 or 2 years after leaving the agency. I thought it was really important that we had that independence, Lindblom explained. I also wanted that done, not only to ensure greater independence or freedom from potential industry influence, but also to help screen out potential employees who might be planning on or open to working for the industry. Current federal rules only prohibit former employees from directly lobbying their previous agencies for 2 years, but they can work behind the scenes advising clients on regulatory strategy, exactly what many former FDA attorneys are now doing. Ethics experts say the current system gives regulated industries an unfair advantage over public health protection. Professor Genevieve Cantor of USC, who studies healthcare regulation conflicts, noted those FDA regulations are super narrow and should be broadened if we were truly interested in preserving independent government. This pattern suggests that relying on regulatory agencies for food and health protection may be less reliable than choosing foods that don't require industrial processing, chemical additives, or regulatory approval in the first place. When nearly 24 FDA lawyers leave to represent the tobacco industry they once fought, it reveals something fundamental about how regulatory protection actually works in America. The revolving door between government and industry creates a system where regulatory decisions may be influenced by future career prospects rather than public health priorities. Your health decisions shouldn't depend on the career ambitions of regulatory officials or the legal strategies of former government attorneys. They're the same regurgitated tactics that has been used for decades. And so my goal is to bring it to the light so that we are just aware of it. So that's it. I hope you enjoyed this video. If so, don't forget to like and subscribe to my channel as we continue to bring these things to light. Thank you for watching. We will see you in the next video.